Picture this for a second. You finally land that prestigious job you've been working toward. You're putting in the hours, you're following all the rules, and then out of nowhere, you're fired. No notice, literally no reason given. Could your employer actually get away with that? Well, what if your employer is the government itself? Can the state just fire its civil servants on a total whim without any justification whatsoever?
Welcome to today's Explainer. We're diving into a genuinely fascinating, kind of mind-bending legal concept known as the Doctrine of Pleasure. Today, we're going to see exactly how a rule that originated with absolute monarchs somehow found its way into the framework of modern constitutional democracies.
Okay, right off the bat, let's clear something up so we're all on the same page. We really need to distinguish between two completely different types of pleasure. We are absolutely not talking about hedonism, the philosophical idea that we're all just chasing sensuous pleasure and avoiding pain. Yeah, we aren't discussing lifestyle choices or your weekend plans here. What we're actually unpacking is a formidable, deeply historical legal rule that governs public employment.
So, this legal concept actually comes from an old Latin maxim, durante bene placito. That basically translates to during good pleasure, or during the pleasure of the appointer. In plain English, it means a civil servant keeps their job only for as long as the person who appointed them, which historically meant the king or queen, is pleased with them. The very second that pleasure ends, so does the job. No hearings, no 2 weeks' notice, no questions asked.
Here is our quick roadmap for this explainer. First, we'll look at the origins of this doctrine in English law. Second, its adaptation in India. Third, the constitutional safeguards in place today. And finally, the role of the judiciary.
All right, Section 1. Origins in English law. The Crown's absolute power.
Under traditional English common law, the crown possessed absolute, completely unbridled power over its servants. The relationship was entirely one-sided. See, the monarch was considered supreme, basically acting as the representative of God on earth, which meant they were literally incapable of doing wrong. Because of this, civil servants had zero fixed tenure. Even if you had a contract, the crown could just dismiss you without a shred of notice or a single reason. And get this, a dismissed servant couldn't even sue the crown to get their unpaid salary.
Now, why such a harsh rule? Well, it actually wasn't just a royal ego trip. It was grounded in public policy. You can see this brilliantly laid out in a landmark 1895 Privy Council case called Shenton versus Smith. The court basically argued, look, if the state had to constantly jump through hoops and prove an offense to a jury every time it needed to fire a corrupt or inefficient official, government work would just grind to a halt. The state absolutely needed that flexibility to protect the public interest quickly.
So how exactly did an autocratic rule like that make it into a modern republic? Let's move to Section 2, Adaptation in India, Teaming and Autocratic Rule.
The doctrine initially arrived in India by way of the East India Company. Then, in 1858, when the rule transferred directly to the British Crown, this doctrine was fully cemented into Indian administration. But over time, it evolved. In 1919, the Government of India Act introduced rules that slightly dialed back this absolute power. By 1935, another act brought in actual procedural safeguards, like saying you couldn't be fired by someone lower ranking than the person who hired you. Finally, in 1950, the framers of the independent Indian Constitution made a deliberate choice to codify the doctrine, but they hardwired it with some very robust democratic safeguards.
And that brings us to a really vital comparison. In the UK context, at least historically speaking, it was all about the crown's absolute, unbridled pleasure. But in the Indian context, as a newly formed republic with a written constitution, the whole doctrine was transformed. It became the president's or the governor's pleasure. But here's the kicker, it is a constitutionally limited pleasure. The executive can't just act like an absolute monarch anymore.
Section 3, Constitutional Safeguards. Let's break down Articles 310 and 311.
The key to all of this is understanding a very delicate balance. I want you to think of Article 310 as the sword. It grants the general power to dismiss, clearly stating that civil servants hold office during the pleasure of the president or the governor. That's the baseline rule. But right next to it is Article 311, which acts as the shield. Article 311 lays out the constitutional safeguards that protect honest civil servants from just being tossed out arbitrarily. Basically, you cannot read 310 without reading 311.
Let's look at exactly how that shield works in practice. Article 311 guarantees some very specific sequential steps before a public servant can be dismissed, removed, or even reduced in rank. Step 1. You cannot be fired by an authority subordinate to the one who originally appointed you. Step 2. A formal inquiry has to be held where you're actually informed of the charges against you. And Step 3. You must be given a reasonable opportunity to be heard and to defend yourself. This makes sure that the basic principles of natural justice are baked right into the system.
Now, what's really interesting here is that for some specific positions, this doctrine of pleasure doesn't apply at all. You can sort of think of them as the untouchables of the executive branch. We're talking about Supreme Court and High Court judges, the Comptroller and Auditor General, and the Chief Election Commissioner. Why are they exempt? Well, these are massive constitutional offices that require absolute, unquestionable independence. Their tenure is specially protected so they can do their jobs without constantly looking over their shoulder, fearing political retaliation.
But wait, just as there are exceptions to the doctrine, there are actually exceptions to the safeguards too. Under the second proviso of Article 311(2), the government can entirely bypass those inquiry and hearing steps in three very specific scenarios. First, if a servant is convicted of a criminal charge. Second, if the authority records in writing that holding an inquiry just isn't reasonably practicable. Or third, and this is a big one, if the president or governor determines it is strictly necessary for the security of the state. This ensures the government isn't totally paralyzed if they're facing severe corruption or a genuine national security threat.
Naturally, this inherent tension between executive power and employee protection leads to some major legal battles. Section 4, the role of the judiciary, balancing power and protection. Let's see how this actually plays out in the real world, through some landmark case law. Way back in 1954, the Supreme Court heard the case of State of Bihar versus Abdul Majid. Abdul Majid was a sub-inspector who was dismissed for cowardice, but he was actually later reinstated. So he turned around and sued the government for the salary he didn't get while he was dismissed. Now, remember, under strict English common law, he'd have zero case. But the Indian Supreme Court explicitly rejected that absolute English rule. They ruled that India doesn't follow the doctrine in its strict entirety, which allowed Majid to successfully claim his arrears. That was a massive, game-changing shift in protecting civil servants.
Fast forward to a monumental case in 1985, Union of India v. Tulsiram Patel. This was the moment the Supreme Court really nailed down the core philosophy behind the doctrine in India. They made it incredibly clear that the doctrine isn't some dusty relic of royal prerogative or feudal privilege. Not at all. It's based entirely on public policy and the public good. The court acknowledged a really difficult truth. Yes, honest servants need security so they can do their jobs without fear, but it's equally terrible for the public if inefficient, corrupt, or dangerous individuals can't be swiftly removed. It is all about striking that perfect balance.
And here is your ultimate backstop. The courts have definitively stated that the doctrine of pleasure is strictly bound by the fundamental rights enshrined in the Constitution. Specifically, we're talking about Articles 14, 15, and 16. That means the government cannot exercise its pleasure arbitrarily, unfairly, or in any way that discriminates based on religion, race, caste, sex, or place of birth. Every single action taken under this doctrine is subject to judicial review. If the government acts maliciously or just on a total whim, the courts have the power to step right in and strike it down.
Which leaves us with a final, incredibly important question to ponder. How do we best balance giving a government the raw power it needs to act quickly against protecting its civil servants from shifting political whims? It's a serious tightrope walk. If you give the executive too much power, you risk creating a deeply politicized, fearful bureaucracy. But if you give civil servants too much protection, you risk an inefficient government that has absolutely no accountability. Understanding the doctrine of pleasure shows us exactly how a modern democracy attempts to navigate that exact tightrope. Thank you so much for joining me for this explainer. Keep asking those great questions, and I'll catch you next time.